How are abortion laws changed? Well, there are many ways to do that. Abortion laws can be changed by way of a referendum, by referring the decision about the regulation regarding abortion to a popular vote. They can also be changed by a parliamentary vote. A very interesting case of a parliamentary vote is a vote on a constitutional amendment. This can lead to a liberalization of abortion, and this can also lead to a more restrictive abortion law. A very interesting case of a parliamentary vote on a constitutional amendment leading to a more restrictive abortion regulation was the Honduran case of 2021. Honduras had already, in 2021, a prohibition of abortion in place. So it seemed a constitutional prohibition. So it seems like not much can be done about it. But one thing could be done that increased the guarantee that abortion would be prohibited in Honduras, and this was raising the threshold for the vote on amending the constitutional prohibition of abortion. Now, these are 3/4 of votes that are needed to change Honduran constitution in this respect. So there is a possibility to do something to make even a total prohibition of abortion more restrictive. Another way to change abortion laws is a decision of a constitutional court. Let's have a look at it. We have many recent examples. We have the US Supreme Court decision in Dobbs. We have the Polish Constitutional Tribunal's decision of 2020. We also have other cases coming from all over the world. And what is so very interesting in deciding about regulation of abortion by way of a constitutional review? It is interesting and it is important to notice that there is a contentious moment to a court decision. Just think about any of your favorite courtroom dramas. Of course, this is fiction and it doesn't have anything whatsoever to do with how the court procedure looks like in most of the countries where these dramas are being watched, like, How to Get Away with Murder. Nonetheless, there is a contentious logic. There is a sense of clashing positions that lies at the bottom of courtroom proceedings in most of the legal cultures all over the world. And in a constitutional court, this is a clash not about interests, about guilt, about responsibilities. It is a clash about law. So it's, so to say, legally speaking, the highest possible form of arguing. It's a very abstract argument about what the meaning of the law is and should be. And the highest law to that, the constitutional law. That is why in these constitutional debates, we get to see the meanings of law negotiated very actively, despite of this debate itself being so very abstract. And a very good recent example of how abortion laws are decided by way of a constitutional court decision is the Colombian case of 2020. This is an anniversary of this decision by which abortion right was extended to 24th week of pregnancy. Colombian Constitutional Court has been known for its very active position in the legal system of the country. And Colombia has been known as a country torn by deep internal conflict, by civil warfare, and also by very deep conflict about the place of the country in Latin American landscape and also in the landscape of human rights protection within the inter-American system. So in this torn, conflict-stricken country, abortion has become one of the key issues on the political agendas. The struggle for liberalization of abortion law, starting with a prohibition, went through many phases, ups and downs, for both parties, arguing intensely in the social media, in the courtrooms, and in the parliament. This impasse was cut in 2022 by the court decision. And before this decision was made, civil society in Colombia went through a period of intense mobilization, both for liberalizing abortion law and for maintaining the more restrictive law in place. In this mobilization, and this is the final point here, the use of human rights arguments was very striking in the way that same rights were used by both parties to the conflict. If you take the more liberal option represented, for example, by the Casa Justa NGO that was instrumental to bringing the case to court, alongside the more usual arguments regarding economic rights, freedom of conscience, etc., Equality of women in unstable living conditions and equality of migrant women was also evoked as a reason to have a more liberal law in place. Freedom of conscience was evoked to cover the freedom of medical practitioners to practice abortion. On the other side, the side that was struggling to maintain a more restrictive regulation, alongside the right to life and the freedom of conscience, this time referring to the right of medical practitioners to refuse abortion, a very interesting argument was made that abortion is also femicide. So abortion is killing women. That is a violation not only of the general human right to life, but also of a very specific right to life of a particular category of humans, that are women. There is also an argument that abortion is torture. So the argument of freedom from torture that has typically been used in order to secure right to abortion for women has this time been used in order to argue for a restriction of abortion right, in order to protect women from being tortured. So in this debate, the semantic instability of human rights has been brought to the fore. And the fact that it was cut by a court decision, of course, brings back all the debates about the separation of powers, about the judicial activism and pros and cons to judicial activism, and also about the democratic legitimation, the legitimacy of constitutional redress in democratic systems. But most of all, to my mind, it clearly shows that the debate about the meaning of human rights in democracy is moving to the courtroom, and the courtroom thereby is regaining its traditional place as a focus of public debate.